All right, we good? Okay, thank you. Good afternoon. My name is Albert Lynn. I am a partner at Hunt & Andrews Kurth, but relevant for today's proceedings, I am the chair of the Federalism and Separation of Powers Practice Group, which put together the panel that you're going to hear from today. I have three very limited responsibilities. First, for those who need CLE, I'm supposed to remind you that you have to check in and check out every day, and you do that by scanning the QR code that's in your program or on placards that are around here. So if you haven't done that, you should go ahead and do that. My second responsibility is to briefly advertise the practice groups. So as I mentioned, Federalism and Separation of Powers Practice Group put together this panel. Practice groups in general have put together some of the other panels, and we also do a lot of the programming that you see online through the Federalist Society throughout the year. It's all staffed by volunteer, people like me who are practicing lawyers, and so if you're interested in getting involved with that, please reach out to Nate Kaczmarek. And then finally, I have the honor of introducing our moderator, Judge Jennifer Elrod. She has asked, or I perceive it as an order, that I keep it short. And so I will do so since I'm in the business of doing what judges ask of me. Since 2007, Judge Elrod has served as a circuit judge on the United States Court of Appeals for the Fifth Circuit. Prior to that job, Judge Elrod was appointed and then twice elected judge of the 190th District Court of Harris County, Texas, where she spent over 5 years presiding over more than 200 jury and non-jury trials. Judge Elrod is a graduate of Harvard Law School, where she was an active member of the Harvard Federalist Society, an Ames Moot Court finalist, and a senior editor of the Harvard Journal of Law and Public Policy. And so without further ado, please join me in welcoming Judge Elrod, who will introduce our esteemed panel.
Thank you. Thank you so much. Well, you come to lunch to hear a discussion and perhaps participate in a discussion on whether states enjoy a special solicitude. So, by a show of hands, do states enjoy a special solicitude? Raise your hand if you think yes. Raise your hand if you think no. Raise your hand if you were just looking for a lunch to attend today that didn't have a full room. Okay.
Are we going to do that at the end, too?
We are going to do it at the end, too. Exactly. Unsurprisingly, a state's Article III standing is often a hotly contested question with increasing attention from the Supreme Court and what some might argue are scattershot results. Are states subject to traditional standing analysis, as this court said in Biden v. Nebraska in 2023? Do they get special solicitude, as the court observed in Massachusetts versus EPA in 2007? Or are there concrete injuries that the court simply will not remedy, as in United States versus Texas in 2023? Is there a common thread to the court's standing analysis? And what does the original public meaning of Article III have to say about state-led litigation? We're so blessed to have such fine panelists to be able to help us navigate that. And I want to first thank the Federalism and Separation of Powers Practice Group for bringing us together and bringing together these experts to discuss the topic. Separation of powers is a principle near and dear to many of our hearts. And as Justice Scalia explained so many times to so many student groups and others, it is the structure of our Constitution and our separation of powers that protect our freedoms in America. So thank you for those of you who spend your time studying and thinking about separation of powers issues. Without further ado, our panelists are as follows. Christopher J. Walker is a professor of law at the University of Michigan. Prior to joining Michigan Law faculty in 2022, he spent a decade teaching at The Ohio State University Moritz College of Law. He previously clerked for Justice Anthony Kennedy of the U.S. Supreme Court, worked on the civil appellate staff of the U.S. Department of Justice, and served on the Senate Judiciary Committee staff for the Gorsuch Supreme Court confirmation. I think that's all three branches of government. He teaches and writes on administrative law and federal courts. He has also chaired the ABA section of Administrative Law and Regulatory Practice and serves as one of the 40 public members of the Administrative Conference of the United States. He also blogs, I don't know when he has time to do that, at the Yale Journal on Regulation. Please welcome in joining Chris Walker, Professor. Next, we have the privilege of being joined by Kyle George. Kyle serves as a principal attorney at the Kyle George Law Group and comes to us with extensive experience representing agencies. He previously served as Nevada's first Assistant Attorney General under Attorney General Aaron Ford, where he supervised over 100 attorneys across 9 divisions. And he was responsible for legal representation of Nevada's state agencies, boards, and commissions, and participated personally in civil litigation and regulatory and administrative proceedings. Kyle George has served as a general counsel to the Nevada governor, counsel and policy advisor to 2 members of Congress, chief deputy district attorney, a litigator in private practice, and he currently advises clients on state and federal regulatory matters and government affairs and relations. He's also a chemist, and we were talking about how that affects his practice. He earned his JD from Georgetown, and he holds bachelor's and master's degree in chemistry from the University of Nevada, Las Vegas. And he served as the president at his school when he was at UNLV. So congratulations, Kyle George. Finally, and not least, but last, we are pleased to be joined by the Solicitor General for the state of Nebraska, Eric Hamilton. As Solicitor General, he is the highest-ranking litigator for the state of Nebraska and the principal legal advisor to the Attorney General. Before joining that Department of Justice, he served as Assistant Solicitor General in the Texas Attorney General's office, and he argued cases in our neck of the woods in the Fifth Circuit. He was also an associate counsel to the president in the office of the White House Counsel. He practiced at Williams & Connolly in Washington, D.C., and he clerked for Justice Thomas M. Hardiman on the U.S. Court of Appeals for the Third Circuit. He holds degrees from Stanford and the University of Nebraska-Lincoln. We have a distinguished panel. Professor Walker, or may I call you Chris, as you said?
Yes, better.
Could you tell us what in the world are we talking about? What is special solicitude of the states? It's very alliterative, but what does it mean?
Yeah, and I think to understand it, we have to kind of go back to standing more generally. So I'll kind of give you my Fed Courts lecture in 60 seconds of standing. So under Article 3 of the Constitution, it says that federal courts have judicial power to hear cases and controversies. And what do cases and controversies mean? Well, during the Rehnquist Court and the early years of the Roberts Court, we got a lot more clarity from the court on standing as a constitutional constraint on judicial review. Lujan versus Defenders of Wildlife kind of comes immediately to mind, but there are a number of cases, especially in the environmental law context, where the court came in and said there are 3 really, really important principles when it comes to our judicial power. In other words, we're not out there just issue advisory opinions. We're not out there to hear general grievances that could be done through the political process. Instead, we're here to hear cases and controversies. And because of that, you have to have 3 ingredients: injury, causation, and redressability. Injury is that it has to be direct and concrete and particularized. So if it's abstract or generalized, that's not usually going to be enough to get you into Article 3 federal court. Injuries also have to be actual or imminent as opposed to speculative or hypothetical. Causation, it has to be that the injury is fairly traceable to the alleged violation that you're saying happened. And finally, redressability, whatever relief you're seeking has to be likely to remedy that injury in some degree. In other words, speculation or probabilities aren't going to be enough here. And so as conservatives or originalists, maybe we'll talk more about originalists, our understanding of Article 3 judicial power was cases and controversies only, not advisory opinions, not diving into issues that could be solved by the political branches. And where we took a wrong turn was in Massachusetts versus EPA. And you all know the case This is about whether the EPA can regulate climate change. The EPA decided that it couldn't, and the state of Massachusetts brought suit to force them to regulate, to issue regulations dealing with climate change. Jonathan Adler, in a Virginia Law Review article, kind of tells the full story of what happened. I'm not going to repeat that here, but I want to give you the basic story. Massachusetts, in its briefing, argued that it had standing and kind of hinted it might have some special standing, but it didn't actually cite the key cases on that. There might not be any, but it didn't go into that. At oral argument, not surprisingly, my former boss, Justice Kennedy, who is a big states' rights federalism person, I love him for that, and I think states are very special in our federal system in that sense, asked the key question and say, what's your best case? And didn't have a great answer to our argument. And he said, well, what about Georgia versus Tennessee Copper? Does that give you state special solicitude standing? Justice Stevens sitting there, an evil genius Justice Stevens, he's just such a wonderful, and he knows, I have an in. There's my fifth vote. Justice Kennedy loves states. He loves federalism. He grew up, in this idea that each state should exercise its power against the federal government. And so you have this opinion that comes out where Justice Kennedy, that's written by Justice Stevens, but Justice Kennedy casts the deciding vote, where Justice Stevens writes for the court, states are not normal litigants for purposes of invoking jurisdiction. They have special solicitude for standing purposes. I'll note as a side note, there were accounts that afterwards that the career officials at the EPA who had just lost the case celebrated. Maybe there was champagne. Maybe that's a topic for another panel at a convention in the future. The academic commentary from originalists and from right of center scholars was scathing, that this upended the standing doctrine, and not just because it recognized that states had special standing, but it watered down the requirements of injury, of causation, and of redressability in ways that would do great damage if it extended to other cases. And that's what we have today, and we see that in the cases we'll talk about from the Supreme Court this last term, that you see this kind of rising up perhaps again of special solicitude standing, where states aren't treated like normal litigants. They're allowed to aggregate the claims of all of their citizens, or allowed to raise other types of sovereign interests along those lines. But I think we'll get into the details in a minute, but that's the basic idea of how states' special solicitude standing differs from what we think of ordinary individual standing.
So does special solicitude apply to all of the prongs of standing, or is it just a prong one tool?
I think it's all of them. So if you think about Massachusetts versus EPA, and again, Jonathan Adler, go read the Virginia Law Review article, so on injury, you can understand one way to have special standing is you're just aggregating the interests of all the individuals there. So they had originally said it's a coastline case, and the Supreme Court, to be clear, Justice Stevens said direct injury to the coastline is one, but there's also injury to all the citizens that the state has within there is another. And so you do have the injury being able to aggregate, but you also have causation redressability of it's really hard for an individual plaintiff to go in and say, if you force the EPA to regulate, my property values are going to be higher. It's a lot easier to go in and say, well, I represent the whole state. All of at least someone's going to have their property values along those lines. So I do think it actually infects all three prongs of the standing analysis.
And one more question, if you don't mind. Is it different than whenever people articulate that they have special parens patriae or special sovereignty concerns? Or is special solicitude just one way of grouping all of those concerns?
I view it as one way of grouping all those concerns. I'd be curious if others disagree, but I think it's a mish and a mash of the various different types. And to be clear, states have had exceptions for certain types of standing that we might go through long before Massachusetts versus EPA, where there's a sovereign interest or some very, very limited parens patriae interest. But I do think Massachusetts versus EPA really kind of just blew it all up.
Okay, well, Chris seems to think Massachusetts v. EPA was the end of the world. These folks who used to be in the Solicitor General's offices or still are, would you say that it's the end of the world, or was it the beginning of all things good for states? Kyle, would you like to take this one? Or?
Sure, I'll take this one. So as a starting principle, the answer is yes. States do enjoy special solicitude. End of panel. Have a great day. So thank you. But I think the more nuanced question is really, when should it be applicable? Under what circumstances is it appropriate to assert, and so on. So Massachusetts v. EPA, I think it was an unfortunate case to really bring this principle forward because of certain issues. I think the biggest weakness in that case is perhaps the redressability part. And I think in the sense they do note that this standing fails as a matter of redressability, perhaps more than the concept that states have a quasi-sovereignty that entitles them to some standing that ordinary citizens would not. I do think going back a little bit further, and perhaps I'm victim to that trap set by the brilliant justice, but I do think that this is truly a states' rights issue. When states ceded some of their sovereignty to join a federal system, I think that we have to retain some sort of check on the federal government, and this is a mechanism by which we can do so. So I do think that conceptually, it's a valid principle. I do think that particular case is a little bit flawed because of other defects, but not the underlying sovereignty that I think underpins special solicitude.
Did you have any initial thoughts? Is it a good thing, or is it terrible, like Chris says? Is the sky falling?
Yeah, I mean, I'm certainly of the view that special solicitude is a good thing for the country. I think you look
Did y'all put this in your briefs when you had briefs, this special solicitude?
I think you see states talk about special solicitude differently in briefs. You have some states that will actually say special solicitude is relaxing standing. When we talked about special solicitude in the United States against Texas brief that Texas filed, we said that states, of course, are subject to the traditional standing analysis, but there is still the special solicitude that is sort of overlaying all of that. As for special solicitude and its effect on state-led litigation, I think it is definitely a positive. There are a lot of cases that would not otherwise be litigated without states as plaintiffs. The private bar has different disincentives to bring litigation that don't apply to state attorneys general. A lot of these cases are very expensive to litigate. Of course, state attorneys general employ public servants. And also, cases can be perhaps not in the best interest of some private clients for other reasons. MOHELA, for example, the state-created student loan servicing company that Missouri has, of course, is not the only student loan servicing company that was affected by the Biden administration's loan forgiveness plan. But I think other student loan servicing companies can reasonably wonder whether suing their federal government client could have a negative effect on that relationship. So I think
Can you tell us a little bit more about the Biden v. Nebraska?
Sure. So Biden v. Nebraska is a case that Nebraska, as well as a group of states, brought challenging the Biden administration's loan forgiveness plan. And the state coalition had a few theories of standing. One was specific to Missouri, and it was that this state-created student loan servicing company was injured by the fact that it would now be processing fewer student loans. But then there were also other injuries alleged. For example, the group of states alleged that the forgiveness plan will actually reduce their tax revenue because the loan forgiveness is deductible, and the states all fix their, or at least this coalition of states, fix their income tax to whatever the federal income tax starts with. And it's very interesting what the court did in choosing to limit its analysis to MOHELA and not go into the tax theory that the other states offered, because I think right now the fight really isn't so much about special solicitude. The United States hasn't asked the Supreme Court to overrule Massachusetts against EPA. It hasn't asked the court to walk away from that term. But the real fight is over theories like that tax theory, what the federal government would call indirect injuries. And the court stayed away from that and instead decided the case on a theory that looks somewhat like you might see private plaintiffs bring.
Okay. So, do you think that the parens patriae and the sovereignty theories are just wrapped up into this special solicitude, or do you think they're distinct theories?
You see them talked about both ways. I think that really goes to are states correct when they are saying that special solicitude is actually relaxing standards? Or are we just talking about these uniquely state injuries, like injuries to my ability to enforce, well, the states, of course, gave up immigration authorities in joining the Constitution. And so there are special injuries that flow from the state's decision to join the Constitution and cede some of their sovereignty.
Right, and that's what Kyle said something about that earlier, and that reminds me of the I see one of my very distinguished colleague, Judge Smith, in the courtroom here today in the lunchroom. Yes,
Can I jump in on
and it makes me think about the DAPA case, where it was on that you gave up your sovereign rights on aliens, and the state argued that it interfered with that, and they relied on Massachusetts v. EPA for that proposition. Go ahead.
Yeah, I wanted to jump in on Biden versus Nebraska, because they took a wrong turn there.
Who took a wrong turn?
The court, the majority of the court, when it comes to standing. And, I mean, Mohela it's a weird setup under state law. Like, it's an instrument of the state, but none of what they gain or lose goes in the state coffers. It operates kind of independently, kind of sealed. It's, to be sure, they're going to lose about $40 million here, although tuition's going to go up, law professors are going to get paid more with student, I should disclose my conflict of interest here that student loan cancellation will only help me, but so they're going to get money on back end. So there are other reasons why they wouldn't want to sue, because at the end of the day, the gravy train's going to just keep on running. And the state didn't have a connection to say, like, we, the state, are going to lose money. We're going to be directly harmed standing in the shoes for Mohela. And the court actually doesn't even go there. Like, Chief Justice Roberts does one of his kind of nice tap dances around it all and says, well, the harm is actually based on Mohela, which the state kind of controls but doesn't really, but like, well, okay, they're part of the state. But more importantly, it's going to hurt all the citizens of Missouri. And brings it back to special solicitude standing, even though they don't use those words. And Gorsuch in United States versus Texas is like, we're not using these words. And Alito's like, wait a minute, like in his dissent in United States versus Texas, like, why aren't we talking about Massachusetts versus EPA? And so I view this as like a really, really, really wrong turn. And just because the court doesn't use the magic words, special solicitude standing, they're in essence just lobbying kind of on to the overextension of that. I don't know if like you all have reactions on that, and I'll just kind of put a plug. This isn't just me. Like, go read Judge Sugarman's article in the Kittle Law Review. Go read Ann Woolhander and Julia Mahoney's forthcoming article, where we all kind of look at this and say, there's really no way to read Chief Justice Roberts' opinion other than a Massachusetts versus the EPA analysis.
Yeah, if I may comment on that, I think some academicians have actually said that the fact that the court is not using that term signifies that it's been eroded in subsequent cases since Massachusetts. I don't know if that's true. I think it's, first of all, to the judge's previous question, I think that parents patriae and state special solicitude, it's a Venn diagram. There's a lot of overlap, but there are some portions of each one of those doctrines that falls outside the overlapping areas. And we don't really need to get into those. The overlap is where we're concerned today. I lost my train of thought on that one. You want to jump in?
Did the court lose its way?
I'm sorry?
Did the court lose its way in finding that Mohela?
No, my point, the point I was making is that the court has been really reluctant to wade into this issue, right? Since they threw this bomb out there, this grenade that exploded with Massachusetts v. EPA, and since then they've kind of sidestepped all the consequences that have come from that have flowed from that. But I don't think it's been eroded directly. I just don't think they found the right case to really expand on the doctrine. As I indicated in the first one, I think the issue with EPA case was redressability was problematic. I think each of these cases, there's another injury, for example, in Mohela might be problematic. So the court, I think, is biding its time for the perfect case where it's a little bit more cut and dry. We can have a clearer pathway on what special solicitude means, because bad facts, bad case, bad law. This is one of those that we just haven't quite found it yet.
So Kyle, you think that they want to expand it rather than put a nail in the coffin and say, no, we're not doing that anymore?
I don't think it needs to be expanded. I think it needs to be more sharply defined. Under what circumstances appropriate? There are some who believe that it should be used solely for procedural defects. There are others who believe that the state should have a much broader power. And curiously, this is one of those doctrinal things that it doesn't fall on ideology. Both conservative and liberal states have relied extensively on this doctrine in the last, dozen years?
Well, Eric, do you think the court lost its way in Biden v. Nebraska?
No, and I,
Sometimes it's a softball.
I mean, yes, the relationship between Missouri and MOHELA is unique and perhaps specific to states, but there still is a tie between the two. The Missouri state government had a role in supervising MOHELA, and MOHELA was kicking back money to the state in the end. I still don't necessarily see that as part of special solicitude, more a wrinkle unique to that particular plaintiff.
Okay.
Can I just, real quick on that? I mean, so you have this, I think we hear everything United States versus Texas, because that comes out, I think, a week before Biden versus Nebraska.
Can you tell us about United States v. Texas?
Yeah, I mean, so United States v. Texas is an 8-1 decision where the Supreme Court says, you, state of Texas, don't have the ability to challenge the Biden administration's immigration enforcement priority policy memorandum. Like, you can't do it. That's not something traditionally recognizable as an injury. And we're not going to do state's special solicitude standard, they don't say that. The one dissenter is Justice Alito, and Justice Alito's like, what the heck, like, good for the goose, good for the gander. Massachusetts versus EPA, it might have been garbage, but it's our garbage now, and let's use it. And by the way, we just used it, or we're going to just use it in a case next week. I mean, you read his opinion, he's talking about the Biden versus Nebraska. We're going to use it there, and then we're not going to say it by name. Justice Gorsuch, joined by Justice Thomas and Barrett, right to respond in a concurrence and say, oh, no, this isn't special solicitude state standing. And I just want to read the quote.
Yeah.
Justice Gorsuch says, before Massachusetts versus the EPA, the notion that states enjoyed relaxed standing rules had no basis in our jurisprudence, quoting Chief Justice Roberts' dissent in Massachusetts versus the EPA. Nor has special solitude played a meaningful role in this court's decisions of the years since. Even so, it's hard not to wonder why the court says nothing about special solicitude in this case. Alito would say, because you're all hypocrites and you're using it, and you're using Biden versus Nebraska in a week. And it's hard not to think, Justice Gorsuch continues too, that lower courts should just leave that idea on the shelf in future ones, which reminds me of like Chevron deference debates, which I know a lot more of this, where the Supreme Court, will use wants the lower courts to use the tools, but when it gets to the Supreme Court, they don't have to follow the same rules. And I kind of just want to ask, if you're counting that, Kavanaugh and the Chief Justice are the only ones that are silent here. I think Jed Sugarman might say that they took the fifth on whether they're actually applying special solitude standing. And I really do think that's the dynamic you have these two cases, and it's really hard. Whether you think there might be other grounds to justify standing in Biden versus Nebraska, I think it's really hard to read Chief Justice Roberts' opinion and not think that he's basically relying on Massachusetts versus EPA. I guess that's where I'm at.
Can I ask a question based on that? So why is there this hesitation to actually say those words out loud? Is it because of a lack of desire to expand it, sharpen it, want to claw it back? Do you have any theories on why that is?
Yeah, I do think, like Chevron being a flashpoint for the conservative legal movement, Massachusetts versus EPA was a big flashpoint. So I think there could just be a political story here. But I think there's something deeper. I do think that most of the conservative justices in the Supreme Court still hold up Scalia and Rehnquist as like the standard bearers on judicial review and don't want to turn their back on what they think is probably the original understanding of Article 3 that does not distinguish in the text between states and individuals. It just says what judicial power is, and really kind of rely on that kind of deep history understanding that you had that really sharpened during the Rehnquist court.
Well, as an inferior court judge, so when it says the lower court should just leave that idea on the shelf, what are we to do? And that's Justices Gorsuch, Thomas, and Barrett. what, are you supposed to write briefs that encourage us to not leave it on the shelf? And are we supposed to, what do we do with this?
Well, I mean, of course, it's a concurrence, so Massachusetts against EPA is still good law, and the federal government hasn't asked the Supreme Court to put it on the shelf. But I do think you're seeing that states recognize they can't just walk into court and wave the special solicitude flag and expect to get a favorable ruling on standing. And so that's why I think, for me, the very interesting takeaway about United States against Texas is you had the parties really very focused on the concept of indirect injuries and whether the chain of causation that Texas had put out there to establish standing was enough, and special solicitude was a part of that argument. But what the court ended up doing is not taking that argument on. Instead, it focused on an argument that really doesn't have much at all to do with the fact that Texas is a state. It's a backup argument for the federal government that got 2 pages of briefing in their brief. And so you still see very much alive this question of how, to what extent can states rely on these indirect injuries? And sure, Justice Gorsuch speaks negatively of the special solicitude term, but in the end, he lands exactly where Texas wanted them to land, which is these indirect injuries were proven in the district court, and they're enough to get Texas into court to challenge the prioritization meta. And then the same thing, of course, is true with Justice Alito's dissent. He would have also allowed Texas to sue on indirect injuries. So I'm very optimistic about the future of state standing after United States against Texas.
So it's a rose is a rose by any name? Is that what we're saying? Or you don't call it that, but
Don't use the magic words. I think Chief Justice Roberts said, read all these opinions and make all the special solicitude arguments, but don't use the magic words.
so that's was that what you would advise other SGs, or would you just
No.
keep using the words?
Yeah, I would continue to use special solicitude, but don't put all your chips, don't push all your chips in on that term. And you do see courts of appeals that will use that term. The Fifth Circuit used the special solicitude term in the Migrant Protection Protocols case that went up to the U.S. Supreme Court. The Ninth Circuit used the special solicitude term just last year in a challenge that Arizona brought to the COVID stimulus tax mandate. The COVID stimulus had this provision in it that said, okay, states, we're going to send you money, but don't use any of that money to offset a tax cut that you enact. And the Ninth Circuit's opinion explicitly said special solicitude in finding that Arizona had standing.
Yes, and just to be clear, we're not talking about any particular cases here today. We're talking about these theories and methodologies. And you know that we learned in the last session, if you went to it, we learned that judges, inferior intermediate judges, they follow the Supreme Court regardless of whether what they think the court might do on another day. And that's their duty. And there was some very interesting discussion on that in just the last panel. Any further comments on this before we go to what is the original theory of state standings? We're going to talk about that because this conference is about originalism. So, but before we do that, any further comments on what litigators should do or not do?
I think the professor is ready.
Okay. So what is the original theory? Why is this, why does this, you seem pretty animated, Chris. You don't like it, and I don't think it's just because, you know, you were pointing out in your view it's good for the goose, good for the gander, or someone thinks that, and so why are you animated about this? Is it because it's not originalist?
Yeah, I mean, I think, yeah. When we go back to kind of the original understanding of what judicial power is, what a case or controversy is, it's really got to have limits, and those limits are actual cases and controversies where someone has a direct injury that's fairly traceable to, you know, and can be redressed by the court. And that doesn't mean that states don't have certain interests that are different than individuals. I think kind of my biggest issue with state special solicitude standing is when they try to aggregate the interests of all their citizens. It's probably more than parents' patriae, although I think regulatory, there's some other areas too we might talk about. And I think the Brackeen case from last term gives us a nice window into that. Like, I don't want to be gloomy. I think the court's aware that this is hard and that they need to kind of cut back. But in Brackeen, the court said, hey, under the Child Indian Welfare Act, the state can bring a challenge under an anti-commandeering principle, that the state itself is being forced to do something under federal law that violates the Constitution. And like, no one's disagreeing with that like that's an interest of the state. They're directly harmed. But what they can't do is bring an equal protection clause challenge, because states don't have equal protection rights. I mean, the only theory you have for that is if you're saying, I'm standing in the shoes of my citizens or my residents, and I'm bringing the case on behalf of them. And I think Ann Woolhander and Julia Mahoney are completely right on this, that if individuals can bring the case, individuals should bring the case. The state should have no role. And if individuals can't bring the case because they don't have a concrete direct injury, states also can't bring the case. You can't water down those requirements. And I just think that's the way that we have to understand case or controversy. Now, I do think there are some contrary arguments, and Judge Sugarman makes them, and you've kind of, both of you made them, that maybe like we should read the Constitution differently and it was built against the federalism. And I'll stop there because I think Kyle or Eric might want to jump in. I mean, I do think there might be some novel, new structural originalism arguments that could be made. I've read them, I haven't been convinced by them, but you kind of discard the original approach that we have, but maybe there's something there.
No, I think you teed that up wonderfully. I do think Constitution should be read more widely, particularly the 10th Amendment in this instance. I do think that that reservation of rights to the states does play into this argument. So when we look at Article 3 standing strictly as that, I understand under originalism you'd really want to be as narrow as possible, but the reality is that we can't ignore part of the Constitution to interpret the Constitution. And I think that it's important to include 10th Amendment analysis and what exactly it does mean to retain that police power in these instances. And that's where it becomes more nuanced and more trouble. If you read it in isolation without the 10th Amendment, you form one conclusion, but once you fold that in, it becomes a lot more difficult to devolve and to really deconvolute. And that's, I think, where our difference is. I don't know that we necessarily disagree on the strict reading of just that Article 3 standing part in isolation would lead to that outcome. I see it as, yes, but we also have to read in other aspects as well and understand the larger structure of federalism to understand what the outcome should be.
Yeah, I'll just expand on Kyle's answer, which I agree with. I think the 10th Amendment is powerful evidence that states are special here, and you see that in other places in the Constitution too. States, of course, ceded some of their sovereignty under the Constitution. I'm not aware of another entity in the Constitution that does that. And also, while the Constitution gives the federal government power to regulate individuals and organizations, it doesn't give it the power to direct orders to the states. So you see in the text of the Constitution that states are unique, and that factors in to the standing analysis when states are bringing cases.
Sure.
I guess I'm a huge states' rights person, American Pie, I'm all there, right? But if it is true, I've always found these structural federalism arguments in the Constitution really frustrating, because if it is true that the founders cared a ton about states and it's all over the Constitution, and it is, how we elect senators, how we elect, it's all over the place, don't you think they would have also included in Article 3 if they really wanted to say states are special there too? Like, that's what I struggle with is, like, you had a whole structure, you had a negotiation, and the fact that it's not there anywhere kind of gives me pause on trying to read it in when it's in a lot of ways, I agree with you, states are all over the Constitution. They're not there though, and I kind of wonder, do we read that silence? Which way? I mean, obviously I think you read the silence differently than I do, but.
Yeah, I mean, look, I think there's a lot we have already read into Article 3, right? I mean, injury, traceability, redressability, those terms, of course, aren't used in Article 3. So this doesn't feel like a huge stretch for me.
Yeah, and I would also respond that I think that presumes infallibility of the founding fathers, right? I know it's difficult to say out loud, but the reality is they could not have foreseen every possible scenario. As someone who's been active in the legislative process for quite some time, every law that's written has some unintended consequences. And unfortunately, this may have been one that was just not envisioned when they were drafting the Constitution. The other part to that is I would also, to follow up on Eric's point, I do think that since the Constitution itself, we've used case law to define what standing means. So the Constitution kind of just gives a word, and then case law has developed it. It's not immutable. We can change our understanding of standing through case law. So I don't think that we're locked into some definition on a given point in time, because we know the words are there, and the words are immutable, but our understanding of it, or the scenarios to which they apply, can change as new scenarios come up. And that's the beauty of what we do, right? That's the entire practice of our profession, that, oh man, we hadn't contemplated this scenario before. Now, how do we apply this to this document? If you're an originalist and you say that document doesn't change, doesn't evolve, well, then we have to find a way to square those two. And that's what this is. This is a new situation that was not previously envisioned. And the reality is, again, if you are a believer in states' rights, that we have to ensure that we don't render states impotent in their ability to counter the federal government, and this is one way to do that without violating the Constitution, in my viewpoint.
Do you believe that there is any historical basis separate and apart from your understanding of the 10th Amendment's role in the Constitution for this understanding of this deference to the states?
As we look at each other.
Yeah.
You go ahead, Eric.
Okay. I mean, you do see this argument that, look, there's novelty to the state-led litigation we're seeing today, and you didn't see this decades or centuries ago. And this is an argument that the federal government made in the United States against Texas. And Texas's response was, well, there might be other reasons why states are bringing more lawsuits now. One is you have the federal government taking a much more expansive role in individuals' lives, but also the way states operate. You have the federal government preempting traditional areas that states operate more often now. And also there are other practical reasons that states might not have been litigating more. One is jurisdiction. Federal question jurisdiction, other than 1 year, did not exist until 1875, and had an amount in controversy requirement until 1980. Another issue is the cause of action. The APA's enactment in 1946 would have eased some concern that states perhaps had before that time about their cause of action.
Half-baked ideas aren't good, but I kind of, actually, they're fun, though. So I'm thinking about the last panel we had on originalism on the ground, and you bring up 1875, and I just kind of wonder, like, what role does the second founding play in this? You know, like, is it, you had a dramatic shift of state to federal power. It didn't change at all Article 3, or, it doesn't say anything about just a review. But I kind of wonder, and I'm not actually making an argument, I just kind of wonder where that fits in. I will say Julie Mahoney and Ann Woolhander, if I read their article correctly, would say that it would be good if we narrowed back state standing in the parents patriae or aggregation sense, at least bar it when it's against the United States, but maybe you can allow it against other individuals or companies or entities. But there's something special about the United States, which I think is the exact opposite argument that you both are making. But I'm curious how that all fits together, and how, if the second founding has anything to say about special state standing.
Any takers?
Not it.
Yeah, I don't know. I haven't really thought about the second founding specifically and standing. I'll point out the distinction you're drawing right with parents patria. Of course, you see that in the SNAP case that points that out. I think there are a lot of interesting questions right now about the extent to which parents patriae still is a viable theory against the federal government and quasi-sovereign interest. Sovereign interest seems to be a pretty, better agreed upon basis for standing.
Agreed, and I think that's one of the reasons I drew a distinction between parents patriae and special solicitude, because parents patriae, then it really does favor the federal government, I think, versus states. So that's why I think there's a carve-out between the two.
So, the authors that you talk about, that their article that I've read their article too, and it seems to say that there's some sort of problem for the court if it takes too many of these cases or adjudicates too many of these cases, that it hurts the reputation of the court in some way. Is that true?
No, I mean, this is another argument that you'll sometimes see the federal government make, right? They'll say, oh, the states are here and they're trying to pull the courts into a political process when they've lost the political fight already. And, my response is that I don't know how that addresses the fact that the student loan forgiveness plan is ultra vires, right? What is the political tool that states have to undo, or I guess enforce the law? And Justice Alito talks about this some in his United States against Texas dissent, explaining that Congress isn't going to be able to like hold up nominations or impeach a president over something like the student loan forgiveness plan as a way of enforcing the limits of the statutes that Congress has enacted.
So does that matter? That there's no way to get a redressability on this? If we didn't take this, if this approach wasn't taken, that there's no one who can adjudicate this? Does it matter? Kyle?
You can go first, Chris, and then I'll
I mean, I've got to play my part I've been assigned, which I almost entirely agree with. But, part of the problem for me is, we live in a very different world where the president has a lot of power to make law through agency action. And it's hard for me to kind of square the reality that we have got other constitutional and normative issues going on that lead to executive branch overreach without Congress's role. And on the flip side, I completely agree with the scholars that say that expansive state standing is just going to be a mess for courts. It's going to undercut the idea that courts shouldn't be just issuing advisory opinions about what the federal government's doing, whether it's good or bad. If it's a general grievance that affects everyone in the state, that's something that we should do through the electoral process. And the more courts are doing that, the more political they look, the less they're doing the role of deciding concrete cases and controversies, and I think that's a big problem. The founders expressly rejected the idea that a Supreme Court would review every law before it goes into effect. We adopted an approach where you had to be injured, go to court, and the like. And I do think the state standing, if we read it too broadly, and I don't think Eric and Kyle are really reading it as broadly as others are, but if you read it too broadly, it's basically any time that citizens, the majority in a state, doesn't agree with what an elected president wants to do within their discretion, even though no one's actually directly harmed or the harm isn't redressable through courts, they're going to be able to have an Article III court kind of declare who should have won the election. And I think that's a really bad way to run a democracy, and to use an Article III judiciary that's tenure protected and not politically accountable.
So is the reason we're in this position, is it all Congress's fault?
So the answer to that question is always yes. Congress certainly, I believe that Congress can more sharply define that type of standing. I do think they have the opportunity to do that, and I would not take issue if they were to do so. I do think the Constitution does give Congress the power to define the contours of federal courts, and that's pretty clear. Is it Congress's fault? No, I don't think in this instance it is for that reason. I just want to touch on your previous question really briefly, the reputational harm to courts if they wade into this. I think it's slightly a cop-out to categorize controversial issues as political questions. And to be clear, there are times, this is a political question, which courts shouldn't wade into it. But I do think that doctrine has been weaponized on occasion to avoid dealing with hairy legal issues, right? There's a real question of law that needs to be settled, and I think it's a bit of a cop-out to say that's entirely political question. And yes, there are times it is, but there are times it is not. But those who don't want an adverse outcome will claim that we'll put it under the umbrella of political question when it's not. So I just wanted to touch on that previous question because I think it's an important issue, not to weaponize political question.
I'll add a little bit to the question of whether Congress is at fault. I don't know that fault is the right word, but it is notable that Congress, of course, enacted the APA and created a cause of action for those who are injured by federal regulation. And that's significant in the standing context because when you look at Massachusetts against EPA, one thing the court really leans on is the fact that Massachusetts had a procedural right under the Clean Air Act. And so you have seen some analogize to the APA and the procedural right that states have there.
The danger with that, though, is that the question is, is this an inherent right of states, which I would argue that is as a quasi-sovereign, versus it's granted to states by Congress? I actually think it's the opposite. I think Congress can take away that power, but if they don't take it away, explicitly it does reside with the states. So it goes one way but not the other in my analysis.
Okay. I think we're going to be opening up for questions soon if you want to get to the microphone to ask your question about whatever scenario you can imagine for these very experienced litigators and thinkers in this field. In the meantime, I note another academic, Professor Tara Grove, has argued that states should have standing to sue only to protect federalism principles when the federal government preempts or interferes with the enforcement of a state law. But she argues that states should not have special solicitude to challenge how federal laws are enforced because state attorneys general have no special insight or interest in the operations of the federal government. Sorry about that. That's what she says. What do you think of this argument? Does it strike you as a standing doctrine that is consistent with the structure of the Constitution, or is it too stingy?
Yeah, what I would take note of in that statement is that she doesn't disagree with the concept, again, my original point, she doesn't disagree with the concept of special solicitude, but questions when and where it should be applicable. So I do think in some ways it's perhaps an unintentional concession on the existence and need for special solicitude. But that's as much as I'm going to say on that. The rest of that question is a little bit hairy. I think it's more difficult to address.
Yeah. I mean, obviously, that isn't my view. I suppose the SNAP case comes to mind, right? So the SNAP case talks about states' broad authority as parens patriae and to assert quasi-sovereign interest. Now, of course, the SNAP case has a footnote saying that the states can't use parens patriae against the federal government, but we know from Massachusetts against EPA that quasi-sovereign interests still survive, so that argument really strikes me as something that cuts against both old and relatively new precedent.
You know, I would just add, I have not given this a lot of thought, but Tara has, and so has Julia and Ann. And they've got an interesting back and forth, or better said, Ann Mulhender and Julia Mahoney in their paper have. They would go further and say that there shouldn't be standing, if I read their paper right, even when the federal law would preempt state law. And their point is that in those cases will make it to, there will be a case or controversy going to the Supreme Court the minute that the state decides to actually enforce their law that is allegedly preempted by federal law. So I think if I read their paper right, their argument is, they're like, hey, Tara, we love you, like, you're awesome, we agree on most of this stuff, but think about this. If a state wants to have that challenge, they enforce their state law, and the regulated entity is gonna bring a lawsuit saying, or in that enforcement action saying, that state law is preempted. There you have a case or controversy that'll make it to the Supreme Court. So it's interesting that they would, I think, even further than say, nope, all this stuff is off the table when it comes to enforcement.
But doesn't that make a time period where those who are affected by the regulation at issue are really they're in limbo? And does that matter?
Oh, is that a feature or a bug?
You know?
In some ways, it's kind of a feature. Maybe this isn't the right crowd for that. I mean, to allow for facts, to have a factual development of a record so a judge can actually issue a decision based on a particular case as opposed to kind of Abbott Labs pre-enforcement review when you don't actually even know how the company's going to, I don't know. I tend to think that there's some value to having an actual factual record before you when you're deciding a case.
Okay. We don't have anybody at the microphone still. Oh, we do have somebody at the
I
microphone.
thought we were controversial enough.
Yeah, no,
Maybe
y'all
we gotta say
have a
something
good, we
crazier.
don't, we're okay if we don't get questions, but it looks like we do have a couple. And please follow the rule that you ask a succinct question. Thank you.
Certainly, Your Honor. Thank you for the panel, all of you. I have a question for Professor Walker to press on something he said in his opening remarks, which was I think in some that special solicitude bears on each of the three elements of standing. And my question is, why is that so for redressability? I think we've seen from the cases that this makes a lot of sense in the context of injury in fact and causation. Those are more malleable concepts. They're a little more underdeterminate. Redressability seems sort of like a light switch to me. It's either on or it's off. You see this in Texas. Like it is a binary question whether vacatur is a remedy that exists under the APA. It is a binary question whether that remedy is barred by 1252F1 if it does exist. There just seems like less malleability. And because there's less malleability, it doesn't seem like special solicitude is working in redressability cases. So could you say a little more on why you think it glosses redressability and how?
Yeah, and I joked with Jonathan Adler before that now that I'm at the University of Michigan, I was going to have him like have a thing in my ear and like kind of steal some signs because he's thought about this a lot more than I have. But no, I mean, when you think about redressability, I mean, you're right that it all kind of bleeds together. I mean, if your injury is the entire state might have some injury from climate change that could be potentially addressed by the EPA trying to regulate climate change, assuming all the predicates that, you know, maybe they could, like maybe the EPA would make a difference in there. The redressability also gets watered down because now they're saying, well, can the court actually address this? Well, what's the injury? Like, what is it redressing? So I think that's kind of where I was thinking of redressability, and I think Jonathan Adler in his Virginia Law Review article goes even more detail of that they do kind of bleed together, and it's the idea of when you ask what's redressable, you have to figure out, you go back to the injury, and you have to kind of tie those together. I don't know if do you have a better answer than that, even though you don't agree with it?
Not really. I mean, I think some of this comes from the fact that states often will suggest theories of standing, right, that the federal government calls indirect. And so whenever you end up with a chain that is part of your theory of an injury, well, then when you're sort of trying to go the other way and figure out how redressability works, it can get muddier. But, I mean, you still have cases like Department of Commerce against New York where there is a chain, but the court is still able to find that, okay, well, if there's no citizenship question on the census, then the New York State's turnout isn't going to be depressed, and then in the end you end up with more federal funding than you might not otherwise get.
Okay. In the back of the room.
Thank you. Matt Bowman with Alliance Defending Freedom. It seems like there's a common thread in a lot of these cases, even all the way going back to Lujan, that these are challenges to federal administrative agency actions. And I wonder if that's not a coincidence. Do you think that there's a significance to that thread, and whether what seems to be this court's increased scrutiny of federal agency action, such as through the clarification of the major questions doctrine, is playing a role in its deciding what the contours of standing are?
I think the APA is perhaps one reason that we see state litigation against federal agencies, and the APA has some unique remedies, in particular vacatur, so that can be somewhat of an incentive for APA litigation.
Yeah, I really like that question. I'm not supposed to say that. I like all questions, whatever. There's an interesting line of argument that states shouldn't have special standing to challenge congressional, laws, but they should for agency action. And I don't know how I don't see a constitutional hook for that. Maybe there's an APA hook for that. But it does address kind of my more underlying concern of, like, in a second best world where we already have an administrative state that looks dramatically different than I think the founding generation, even the second founding generation would have ever imagined. How do you address that? The fact that agencies are doing things that in the past wouldn't have been done at all, or at best would have required more direct legislative authority. So I don't know, but I think that's a really interesting thing to think through. And I can't remember off the top of my head who has made the argument that we should treat statutes and regulations differently.
Yeah, and I find that's an interesting argument as well, and I'm not quite sure where I fall on that. On one hand, members of Congress are elected by people from their states, and therefore you can say they are the voice of their citizens, whereas regulatory actions are more divorced, more removed or distanced from the people itself. And perhaps that's the reason that there's a carve-out or there's a distinction between regulatory action versus congressional. I do think it's an interesting theory, and I would like to spend more time in the future kind of fleshing that out in my own mind, because it feels, intuitively it feels like there's some legs there, but I haven't quite navigated that yet. But again, I too like that question, because it's an interesting one that talks about representation of people, going back to the fact that states are the embodiment of the people more so than the federal government, and therefore if a person elected by the people act on their behalf, it's different than if an administrative agency does.
Okay. Professor Soman?
Ilya Soman, Scalia Law School, George Mason University. When I was a young law professor and I used to argue for loosening standing requirements, it was mostly liberals who agreed with me, conservatives didn't like it, and now it seems like it's at least partly reversed, but I have stuck to my guns. And so my question is, why, instead of having special solicitude for the states, why don't we just simply make access to court easier for everybody, whether they're lucky enough to be a state government or not? Because it seemed to me in the current doctrine have ridiculous anomalies, such as even $1 of a supposedly particularized injury is enough to get you standing. On the other hand, $430 billion of harm to taxpayers is not, even though the harm is just as tangible and real. I know the argument is made, the political process can handle it, but all the time courts hear all kinds of cases that potentially the political process can address. So why shouldn't we at least have taxpayer standing for cases where there is an allegation that the government is engaged in illegal expenditures? If the legal theory is wrong, it can be thrown out on Rule 12b-6 or other such substantive grounds. But it seems that I don't understand why we can't just open the doors to other people who clearly have injuries at least as severe as those that are taken when they're supposedly particularized. Thank you.
So I'll take first shot at answering that one, because I think that idea is slightly terrifying.
I find it
He
exhilarating.
gets that a lot.
Slightly did a lot of work there.
I know. I'm being gracious here. It's terrifying because then it threatens to undermine every single executive action. And, we have an executive government that's already massive in size, and the idea of litigating every single decision by the executive branch under various additional standing rules like taxpayer standing and so on is terrifying because of the sheer volume of litigation that result. And having worked in state government where it's certainly scaled down, I can tell you that we deal enough with frivolous lawsuits, or at least litigation that I would define as frivolous. And to amplify that or to scale it up to the federal government, to me, is a daunting proposition. And I think that, in my mind, that would be a little bit a bridge too far. Speaking from my political hat, not purely legal, there might be certainly basis in law to support that argument, but I can tell you just as a matter of practicality and politically speaking, I think that's problematic.
I mean, what could go wrong if every time one citizen does not like one law that's been passed or goodness. Courts would have a lot of fun with that. We'd have a lot of trust in courts. I do want to, though, push, I do think this underscores why an extreme version of state special standing is also wrong. As I understand, it's kind of more like, well, we're not going to let millions or hundreds of millions of people sue individually, but we'll let 50, sue. And I think that some of those same arguments that might terrify you about individual standing being whoever doesn't agree with the policy that's been made, I think also applies to states in really dangerous ways. Again, I don't read either of you pushing for the really extreme version of state special standing, but I do kind of worry that that's where we end up. Now, on the flip side, maybe there's some good arguments. When a state decides to bring a lawsuit, an attorney general has to decide who is politically accountable, who at least represents a majority of the people, and there are certain types of political checks that limits the dispute that a court hears to more democratically accountable actors as opposed to just some random. I don't know, but I do kind of worry. At least the extreme version has the same problems as Ila's question does. Although Ila's all in.
See it as a feature, not a bug.
We should have had you up here to be like, everyone should be able to sue. Yeah.
They should, but I should turn over the podium to
Okay, in the back of the room. Thank you.
Good afternoon. Chip Miller with the Institute for Free Speech. How do you square, kind of this tightening of special solicitude for the states, particularly by SCOTUS, while other courts, a lot of federal trial courts, MDL courts, are expanding, standing, almost like parents patriae for like municipalities. And you have these class actions or mass actions on behalf of, supposedly every political subdivision in the country, bringing claims against opioid industries and things like that.
Have you thought about this stuff, or?
I'm not sure I heard the question. It's how do you square state standing with class
With
actions?
the class, mass actions and class actions. Did you want to elaborate a little bit?
Yeah. So like, a lot of these are being brought now on behalf of municipalities and political subdivisions, and so they seem to be getting, more standing than they've had in the past. While at the same time, there's this, restriction that seems to be being placed now on the states more. It seems to be a contrast.
So, I mean, we should have a whole panel on municipal class actions. I think it's like one of the worst developments that's happened in American law in the last, maybe that's an overclaim. But like, the way municipalities are leveraging, state standing, the way that plaintiffs' litigation is working to do contingency work with cities, I think is deeply problematic. And of course, that's a matter of state law. Legislatures can do state legislatures do a much better job legislating to make it clear that municipalities can't do that. I teach local government law. I think this is like, can a city actually agree to hire an outside lawyer on a contingency fee basis without going through an issue? Can we referendum that? I mean, there are all these fun questions when it comes to municipal class actions and the way that municipalities assert standing and bring lawsuits that really needs a lot more attention from the academy and from the real world.
Any other comments? No? Okay. Yes, sir.
Hi, great. A terrific panel, and I really appreciate the engagement. And Chris, I thought you made several really important arguments about the 14th Amendment and Reconstruction changing the scope of state sovereignty. I guess my question is still the way that you're structuring the default rules. So Article 3 cases, it's not like Article 3 has concrete imminent injury and traceability and redressability. Those are all interpretive, historical, originalist moves from a very open-ended text about cases and controversies. And so you're setting up a default rule. Why didn't Article 3 mention special solicitude for state standing? I think the question is, why should that be the default rule? It seems like as long as there is some fit to case and controversy, then the 10th Amendment would still apply. And so this also is about Reconstruction. The default rule goes the other way with state sovereignty. The 14th Amendment only abrogates state sovereignty with respect to what is enumerated in the 14th Amendment. So if anything, the doctrine cuts the other way. State sovereignty is preserved, and the 14th Amendment, at least our interpretation of the 14th Amendment, is it only narrowly abrogates state sovereignty. So I just wanted to ask you about those default
No, I like it. I mean, this is the problem with throwing a half-baked idea on the Reconstruction, second founding. No, I mean, I think on the first, I think you're right. I mean, it says case, when we're dealing with federal questions, it says case. What is a case? And you have to figure out what a case is. I think if I just go back to kind of the first move is, I have a hard time seeing why a case would differ based on whether it's a state or an individual. So I kind of like that. Now, whether the rest of the prongs are like, right as an original matter, or if this is just the administrable way to identify a case and it has a common law feature to it, like way beyond kind of what I've thought through. But I do still get stuck to the idea that it says case, and we don't have anything in the Constitution that suggests we're treating states differently there. Although I can predict some arguments, and we've heard some of them already, why that maybe we should treat them differently.
Any others?
Yeah, I mean, I just point out that states, I think, are still applying the three elements of standing, right? I don't see states showing up in court and saying, redressability, I'm not going to be talking about that because I have special solicitude. It's, I think, more about how do these three elements mesh onto states which are one-of-a-kind creatures under the Constitution.
So I wish I had made my points as elegantly as you did. I think you encapsulated my position on it pretty well. I think it's tempting when we look at an issue to apply that that doctrine to every case. And to just follow up on Eric's point, just because states solicitude exists doesn't mean that states will just beat that drum each and every time. We can still resort to traditional notions of standing on occasion, but if those are absent, we can use this as an additional theory, not as a sole theory for state standing.
Yes, sir.
Yeah, Brian Bishop from Rhode Island. I'm wondering, one of you gentlemen mentioned a kind of theory that had been expounded in a law journal article regarding states potentially having strong standing where their own powers are invaded. And this is one thing that's right. We're talking about, again, the state trying to tell the federal government how to exercise its powers. I'm very concerned about whether or not the invasion, I mean, the dormant, we're so sensitive to federal powers that we have a dormant commerce clause. Should a state, God forbid, come close to treading on a federal power, it seems to me we need a kind of almost a dormant federalism standing for the states to always have standing when the federal government essentially invades the police power or attempts to seize it on commerce or regional grounds. At least that would be some check, which we have yet to see on the Commerce Clause power.
I mean, I think the Mahoney Woolhander answer would be the state can enforce their law and the individual will challenge that in court, and you will then eventually, if the Supreme Court cares enough about that issue, we'll have a ruling from the Supreme Court that says the federal law can't intervene in the state. I mean, I think that would be the answer. My guess is that's not going to be satisfying for you because there is the delay involved. But I think there's an easy way around that, if that makes sense.
No, it's not the delay that worries me, but I'm talking not about a state enforcing its own law, but about, say, the federal government making a law that effectively invades the state's prerogative. So it's not at that point up to the state to enforce its own law. The state needs to be able to bring an action to say that the federal government is invading the state prerogative.
Oh, interesting.
So like hypothetically, if the federal government were going to get into the insurance business or something like that, or the healthcare business or something, then is that what you're talking about, sir? I'm trying to figure out what would be a hypothetical.
Right, it's
where sometimes they get into businesses and those police powers, traditional law enforcement, police, even regular, but
criminal jurisdiction even.
Criminal jurisdiction where, I think when my colleagues, some of them started on our court, we had very small percentage of federal criminal laws being part of our docket, and now 50% of our docket is federal criminal cases. And so it's been a vast expansion of the federal. I'm not agreeing with you. I'm just trying to articulate what is your question.
I know, right,
as
and
to
our
try to
legal
tease
shop-
out your question. Go ahead.
Yeah, I think that you do see states show some sensitivity to this. The Kentucky against Biden case in the Sixth Circuit does a great job of, it just really does a deep history on parens patriae standing and goes through a number of different injuries that Kentucky asserted. And one was, I think, what you're touching on, which is, hey, healthcare, vaccine rules, that's our ground as states. That's our traditional space. And not only is it our traditional space, we have contrary vaccine regulations in our state, and those injuries are within parens patriae. They're quasi-sovereign injuries that entitle us to standing.
Yeah.
Okay.
Great, thank you.
Thank you. You have the benefit of having the last question of the session, so make it a very good one.
I will try, Your Honor. Cameron Atkinson. I was struggling in the context of discussing state standing, if it's still possible to formulate an originalist view of state standing when we had an intervening structural change on how senators and reps are elected to Congress, and that we switched from state legislatures selecting them to a popular vote. And conceivably, you could see under the original system that a state doesn't like what the government's doing. They instruct their legislature, their representatives in Congress, do something about it. And then that becomes the structural check on federal power. So I am wondering, is state standing in Article 3? Is it possible to formulate an originalist definition of that, or did the founders understand that it would be more of a instruct your legislator in Congress?
It's a really interesting question.
I think
So does the 17th Amendment, et cetera, impact why this interaction and this question in any way?
I think it's a fascinating question, and I was, of course, complaining earlier about, well, okay, if states can't do this, what are they going to be able to do? And yeah, for a long time, I think states' abilities to send representatives to half of the Congress would have been a useful tool, but I don't know that it also goes all the way, especially when you then have actions that are more targeted to executive branch implementation of the law. Right, senators are going to be constrained in how they can respond to executive branch actions that are they perceive to be unlawful.
Any final observations? No. Okay.
No, this is fun.
Well, we should give them a big hand because they've done a lovely job. And sir, your question was a good one, so well done. I need to make a couple of brief announcements before you are excused. There are book signings available on the mezzanine level just after this program, and so I'm supposed to let you know that there are these book signings, and then the next program will happen. So thank you all for joining us for such an interesting discussion. This is one of the benefits of coming to these programs at the Federalist Society that feature diverse, intellectually diverse speakers, and to be able to talk about important constitutional issues with intellectually diverse speakers is a blessing in our country. So thank you.